Hi guys, welcome back to my channel. This is Battle with Ola. My name is Mujola Olua and I'm so thrilled to be here once again. Today I want to talk about the whole process of criminal defense in Nigeria, how crimes are defended, and the options that are open to the defense or the defendant and his lawyer in a Nigerian court. I've talked about how crimes are prosecuted, and I've talked about how to open a case in Nigeria from the prosecution's perspective. But when it comes to the defense, what are the options available? And we're going to be talking about a no-case submission. We're going to be talking about resting the defense's case on the case of the prosecution. And then we will close with entering your defense, which I believe some other videos that I've done on, opening a case, I've shed some light on. Now, someone asked me by email, a senior, he asked me why I had not done a video on a no-case submission. So I said I was going to do this video. But then, as I was preparing to do the video, it kept on, something kept on coming to my mind as if I've done the video before. So I had to go and check. And I saw that it was one of the earliest videos that I did on this channel. Although at the time, I was really talking about how I obtained my first judgment, a ruling actually, as a Nigerian lawyer, and that was way back, a few years ago. So I talked about it from that perspective, but towards the end of the video, I talked about a no-case submission in detail. So if you are interested, I'll link it in the description box. I talked about a no-case submission in its entirety, I believe, in that video. If you start watching from 5 minutes to the end, I think it's about an 8 minutes video. So it's like the second video on this channel, or the third, either the second or the third video on this channel. So if you can scroll down through all the videos, you will find it. But I'm going to do have a do-over in this video as well, but I'm also going to talk about some other things. So thank you, senior, for asking for that. You can see it in the previous video and you will see it in this video as well. Before I continue, I'd like to tell you that my fiction book is still on Okada Books. Please patronize me. Buy my book. It's 1,200 naira. That's about $2, or thereabouts, based on the current exchange rate. But please buy my book, buy my fiction book. That's one. The second thing is that I wrote something about my mediation practice, how alternative dispute resolution, especially mediation, is shortening the wait time to justice in Nigeria. And I really want you to read it. I'll link it in the description box as well. Please read it. It's published on Barrister NG and on the Nigerian Lawyer. Those are two popular Nigerian blogs for law content. So please, I'd like you to read it. I've also listed it on my academia.edu page. Please follow me. My writings are as important as my law discussions, and I take them, very seriously. And it's a thing of great honor for me when people can read my writing and relate to it and learn from it, and it can be of benefit to them. So I'm already getting reactions based on my recently published article on mediation and reducing wait time to justice. So I'd love for you to also read it and probably send me feedback at houseoflivingstones@gmail.com and share it far and wide. So let's get into the video for today. We're going to be talking about a no-case submission first, and then we will go on. So what is a no-case submission? When a defendant has been charged with a crime in Nigeria and is being brought to court, the charge has been filed by the Office of the Director of Public Prosecutions, and or by the police if it's at the magistrate court, and the defendant is brought to court. There are several options available to the defendant, and one of them is to allow the prosecution, open their case and close it, and then enter a no-case submission. That's one. Rely on the case of the prosecution. That's two. Or enter his or her own defense. And a number of ways can be, and there are a number of approaches to entering his or her own defense too. But one of the the options available is to enter a no-case submission, which is what was done in the case that I talked about, in that earlier video about no-case submission. So it was, I just joined a law firm post-call, and then they had entered a no-case submission in that case, and then I was sent to court to go and get the ruling. That's basically what happened, why I got. And that's basically how I got my first post-call ruling. I remember that day because I was working with the principal that was too busy a politician. So I remember that I was in the office. I didn't even know that I was going to court. I didn't think that I was going to court. Or maybe I thought that, oh, my principal would come and then we would go to court together. And then that day, the clerk just told me that some people are waiting for me downstairs and the principal has instructed me to follow them. So me, I carried my wig and I followed them. A man, two men actually, in a van. So because I had to sit in front, one got down, the father got down and entered the open back of the van, sat in it. So the carriage part, the open carriage part, you know, it was like a Hilux, but it wasn't really Hilux. So I sat with the driver and then we're going to court. I didn't really know anything. Then my principal now called the man at the back and the man now gave me his phone. That's when my principal now explained to me that, oh, they are a client, so it's a criminal matter. I'm going to obtain the ruling on the no case that he had filed. An earlier associate that left the firm had filed, you know, on their behalf. It was until I got to court, you know, that day was a full court day. We got to court around 9 or to 9 before the judge, the magistrate, was a magistrate court. And then I was the last person to do my case. I've talked about that too in a couple of videos, talking about how, you know, seniority at the bar, how it works in Nigeria. So it was basically just me, the prosecutor, and my clients at the end of the day, you know, around about 1 p.m. And I had not even been able to go out to probably even eat or drink anything because I didn't know when they were going to call my case. And, you know, I was new in the jurisdiction, so I had to stay put before anything would happen. My principal would start shouting because the man could yell a lot. So anyway, the case was called, and that was when I found out that it was a case of, I think it was armed robbery. But from what I garnered from the case, what had happened was that the defendant, did I get a file? I'm not sure if the case had the file or if I took the file to court. But I was able to, you know, gather, I think either from the file of when the case was called, I was able to gather that actually what had happened was that the man, the son that had driven me to court, can you imagine, was an ex-police officer that had been, I think, was dismissed or fired. I don't know, I'm not certain. And then he had been accused of robbing, you know, the evidence room. So he had been accused of robbing the evidence room, the police evidence room. So he was arraigned and charged. So I think he was arraigned and charged with either burglary and stealing or robbery or what have you. So the associate that left the firm before I came had filed a no case submission, and I went to court to get the ruling, and the ruling was not even in our favor because even when the judge was reading the ruling, I knew that this no case could not fly because, man, what had been filed was quite watery. I'm sorry to say that because I have the utmost regard for, you know, my colleagues at the bar. But I also learned from another associate that I met in the firm that, you know, there were some peculiar circumstances based on our principal's treatment of associates that might have necessitated filing such watery whatever. But that's not the case. But that's not the discussion for today. So we filed a no case. And that was after the prosecution had opened their case, called their witnesses, given evidence, and then closed their case. That's when one can file a no case. What you're saying by filing a no case submission is you're basically telling the court that the prosecution has no case against your client. That is, you're telling the court that from the totality of the evidence that's been adduced in this case by the prosecution, no reasonable judge or tribunal will convict anyone, will convict my client, the defendant, on this evidence. Your evidence, you're telling them that the evidence is so watery, it does not link your defendant, that is your client, it doesn't link your client's success, it does not sufficiently link your client to the crime, or it does not even prove the ingredients of the offense. Let's say, for instance, now, the offense of murder. If you want to talk about murder, there are some things that must be proven. That one, somebody died. You have to prove that somebody died. Two, and that person is the victim of the crime. And two, you have to prove that the death was caused by the defendant, that is the accused person. And then you have to prove that there was malice aforethought, not just an happenstance, because that would be can be reduced to manslaughter and what have you. But you're saying that this murder, this killing was premeditated. That's when murder can fly. So if you find as a defendant or defense counsel that when the prosecution was leading evidence or conducting their own case, they did not or they were not able to prove that it was your client, the defendant, that actually killed the person, or they could not even prove that anybody died, or they could not even prove that there was malice aforethought, that means that they have not been able to prove all the ingredients of murder. So you can file a no case and tell the court that the prosecution has no case before this court. Fling out their case and release, my client. So that's what a no case is. You are telling the court that from the totality of the evidence led by the prosecution, no court would convict the defendant, on such evidence, because it does not prove the crime alleged or does not link your defendant, your client, to the crime. So that is when you come and file a no case submission. Because it's an option, it doesn't mean that that's what you should do. Because I know that there are some defense counsel that would like to file a no case submission to buy time. But if you're buying time, that would mean that probably your client is already on bail. I've done a video on bail. I'll link it in the description box. Please watch it. Because if your client is in custody and you're buying time for what? It could be for other reasons. Maybe you're trying to protect your client from public outrage, if it's still a fresh matter or what have you. But most times, lawyers file no case to buy time if the accused, that is their client, the defendant, is on bail already. But you don't have to do that. Do not waste the time of the court. So I think that there should be penalties for people who buy time in cases, instead of allowing cases to go on smoothly and let everybody go about their business when we know the decision of the court in time. But filing a no case is very sacrosanct. Do not use it to buy time and do not waste the time of the court. So you file a no case when you have been able to ascertain the circumstances that I've explained, before. So after you have ascertained that, you file a no case, the court will now rule on the no case. Now, the court can either uphold, the no case or overrule it. Where the court upholds it, it serves as a discharge and an acquittal. That is, the slate is wiped clean for your client, and your client can go a free man. And if there's a subsequent charge or prosecution on the same matter, your client can claim autrefois acquit. Autrefois acquit, I mentioned it when I was talking about arraignment. Autrefois acquit is one of the pleas in criminal litigation Nigeria that an accused person can say that an accused person can use to say that I have once been acquitted. Autre is other and foi is time. So acquit is acquittal. So it's like saying or acquitted. So it's like saying autrefois acquit, or acquit. I have been acquitted on this matter at another time before now. So if a no case submission is upheld by the court, it is the final judgment of the court in that matter. And so an accused person can use autrefois acquit to say as a bar to being tried again for the same matter. But I know that in the magistrate court of the northern states that are under the Criminal Procedure Code, CPC, it is merely a discharge but not an acquittal. It's very important to know this difference for law school purposes and for practice purposes as well. Because I know that there's a difference. That there's a difference between an acquittal and a discharge. I might do a video on that. The difference is that a discharge is like saying go. In this instance, you can go and say no more. But it's not an acquittal in the sense that your slate was not wiped clean. We're just saying that for now, the prosecution has no case against you. So if the prosecution should go and regroup and, put their house in order and come back, they can still try you for this matter. But a discharge and an acquittal is saying that you have been acquitted of this crime. The slate has now been wiped clean. So you are going as if you never committed the crime. But a mere discharge is that we're not saying you did not commit the crime. We're just saying that the persons that brought you to court did not put their house in order, so they were not able to nail you to the crime. So you can go, or maybe something happened, an intervening factor, so you can just go for now. But if somebody now puts together a case, and puts their house in order tomorrow, you can be convicted. So it is a discharge. But an acquittal, a discharge and an acquittal is saying go, you're completely free. So that's the difference. So that's what happens when the court upholds, a no case submission. But if the court overrules it, the court will command the defense to enter their defense. Like in the case that I spoke about, the court overruled our no case submission and ordered us to enter defense. That is, we are being asked to file our defense as we would have, ordinarily. Ordinarily when the prosecution closes their case, the defense is supposed to open its own case. But in this instance, the defense decided to go and file a no case submission. Yeah, but if the court now overrules it, the court will now say, defense, please enter your defense and let's get on with the business of this. So that is what happens when a no case submission is overruled. Another instance, I've mentioned 2 instances. I said that when the prosecution fails to prove an ingredient of an offense, or when the evidence led by the prosecution is so weak that no reasonable court will convict on it. And a third one that I also want to add is when the evidence of the prosecution has been too or so discredited during cross-examination. What do I mean? You know that when the prosecution is calling their case, making their case and calling their witnesses, the defense is allowed to cross-examine their witnesses. So if during cross-examination, the defense has been able to discredit the witnesses and the examination of the prosecution so much, that it has so weakened their case, the defense can then, when it's their turn, file a no case submission. So those are 3 instances. They might work together, or it might be just, one of them, that the defense can say that as for this one, they have not been able to satisfy this one, so we are going to be filing a no case submission. So those are instances whereby the prosecution, so those are instances wherein the defense can file a no case submission. What's the usefulness of a no case submission? It saves time. So it saves the court's time, it saves the defense's time, and it saves the prosecution time too. So if they file a no case and it's upheld, the judgment will be delivered in good time, and prosecution can go and prosecute other matters, go and attend to other business of the state. And the judge can also free up his or her docket and, attend to other businesses. And the defense can go home on time. And then the defense counsel can also go and mind other businesses. So it saves time. So that is, and then it saves resources. So the resources that the defense would have spent, in calling witnesses, filing this or that, once they file a no case, it saves that time. And if it goes through, it just saves the resources of everyone having to maybe listen to their matter, maybe call an interpreter if they have a witness that cannot speak the language of the court, which is English language in Nigeria. It just saves time. So that's how a no case submission, those are the importance or effects or the usefulness of a no case submission. Now, the defense can decide to file a no case submission on one count. For instance, if someone has been charged with burglary, stealing, rape, that's a 3-count charge now. The defense can decide that on the count of rape, we're filing a no case submission. We are telling the court that the prosecution does not have a case as for rape, because the evidence that's been front-loaded and adduced by the prosecution, even during their own case, has not successfully linked our client to the offense of rape. So that, or it could be on all counts. So whichever the case, the court will make a ruling on the no case as to the particular count filed. So if you have 3 offenses like I mentioned, and the defense is only filing a no case on rape, the court will rule on rape and then order defense to enter their defense on other counts of the charge. So that's how it works. Where the court is upholding the no case submission, the court must make a detailed ruling. So the ruling will be like a judgment of the court on the no case submission. So it's That's why I called it a judgment in the earlier video, my first judgment. So it's more than just a ruling, as in ruling on emotion and a counter affidavit and what have you. You know, it's a ruling that must contain a ratio decidendi. Ratio decidendi is the reason for the decision in Latin. So judgments must contain ratio decidendi, and usually will contain obiter dictum. I'll talk about that in another video. But a ruling on a no-case submission by a court must be very detailed, must tell us why the court is deciding that this no case is being upheld and that the prosecution really does not have a case against the defense. And when it is being overruled as well, the ruling must be brief now, not as detailed as when it's been upheld. So the ruling must be brief where it's been overruled, so that the court will not fetter itself, you know, when it has to make a judgment on the defense and the prosecution much later. You know that when it's been overruled, the court will ask the defense to enter their defense. So the court must not descend into the arena and must not prejudice, you know, the defense. So the ruling must be brief when it's been overruled, such that the court will not have, you know, fettered its own discretion, you know, for the future judgment. So and the court must limit itself to the issues raised by the defense. So the court must not go, you know, on a frolic. So you must limit the decision in the ruling to the issues that were raised in the no-case submission by the defense. The court should not also give an opinion on the evidence before it. Okay, so the court must be very extra careful where it's overruling a no case, so that it does not affect, you know, the continuation of the case, of the trial, and the eventual judgment. Very important. Now, if the court is making an order for the defense to enter its defense, that is, your no case was not acceptable to us, please enter your defense, then the defense has three options. It can make an unsworn statement from the dock instead of entering, you know, the witness box. And then in that case, you know, less weight will be attached to the statement. So, or it can decide to enter the witness box and give a sworn statement, sworn evidence, to which greater weight will be, you know, attached. Or it can decide to keep mute and not say anything, you know, and arrest his case on the case of the prosecution. That's another aspect that we want to talk about. What does it mean for a defense to rest his or her case on the case of the prosecution? It's different from no case, because for no case, you have to really file, you know, a no case submission. You have to file a process. That is your no case submission, which the court will decide upon. It's like you're filing a written address, you know, and what have you. But in the where you address all the issues that you are claiming support the fact that the prosecution does not have a case against your client. But when you're resting your case on the case of prosecution as defense, you're telling the court that I don't have anything to say. Whatever prosecution has said, just decide on it and let me know my fate. That's what you're telling the court. So that's what it means for the defense to rest his case on the case of prosecution. Now, this option is available if you feel as a defense or defense counsel or lawyer that they don't have a case. Their case is so weak. There's no need for me to bother myself. So let's just rest on their case. So if you're not certain, you're not sure, you know, from the evidence that's been led by the prosecution, that they do not have a case, please don't rest on their case. So don't shoot yourself in the leg as the defense, and as the defense counsel, please don't jeopardize the future of your client. Very important. So you have to be very smart about this. Have you ascertained that their case is so weak and cannot convict your client? If yes, rest on their case and let everybody move on. So that one saves time as well. So in that case, you don't even need to file anything. You just address the court when you are called to enter your defense. You tell the court that, my lord, will be resting our case. The defense rests on the case of the prosecution. My lord, will be resting our case on the case of the prosecution. So that is it. And then you start to address the court that because, my lord, from the evidence that's been adduced, it is so certain that they have no case against my client. Then you start to talk about it. Witness so said, witness so said. My lord, this is saying that. My lord, from the document that was tendered, you can see that so and so and so. So make the address very elaborate. Point to all the loopholes that you see that assures you that they do not have a case against your client, and then close your case and say, my lord, that will be all for the defendant or for the defense. And then the prosecution can reply you if they have any reply, and then the court will now decide based on that oral address and resting and the case of the prosecution. You know, they've opened, they've closed their own case. So the court will now decide based on that and give its judgment as due. Resting on the case of the prosecution is advisable if, one, their case is so weak that you know that the court cannot convict your defendant or your client on their case alone or on the evidence that they have led alone. And two, if you feel that or believe that your no case submission was wrongly overruled, you can still rest on the case of the prosecution. Although the two are different, but if you lose out in one and you still believe strongly that there's nothing for you to defend, you can rest on the case of the prosecution. Those are instances where it's advisable to do so. Also, if a defendant keeps mute or refuses to do anything, it will be assumed safely by the court that you're resting on the case of the prosecution. So if it's time for you to enter your defense and you refuse, we can safely assume that you want to rest on the case of the prosecution. There are one or two differences between resting your case on the case of prosecution, like I've explained, and filing a no case submission. Number one is that if you're filing a no case submission, you're telling the court that the case of the prosecution has not disclosed any prima facie evidence, no evidence on the face of it. That's what prima facie means, on the face of it. That is, any reasonable person that watched the prosecution when they were, doing their own case, calling the witnesses and all of that, can assume or decide or come to the conclusion that they did not disclose any evidence, sufficient evidence or prima facie evidence against the defendant, your client. So that's why you're filing a no case submission. But in the case of resting on the case of the prosecution, what you're telling the court is that their case is so weak, even though they've led evidence, but it is so weak, I know that the court cannot convict my defendant or my client on their case alone. So I'm resting on their case. Let's get this done with. That's one. And two, you know that in the case of a no case submission, if the court overrules it, the court can ask you to enter your defense. But in the case of resting on the case of the prosecution, it's final judgment too. Final judgment. You don't have a comeback from that. So you have to be careful as a lawyer when you decide. So if it's not so certain for you, why not just go ahead and defend your matter? Call your witnesses into the box, and defend the matter. Fully defend the matter, and then let the court decide. But if you are sure that the case is weak or that there's no substance to it, you can either go for a no case submission or rest on the case of the prosecution. So that is how to go about defending your matter. So if you want to defend your matter, how do you go about it? When the prosecution closes its case, you can tell the court that you're ready to open your defense, or you can pick an adjournment to open your defense. And you do the normal route. You open your case by calling your first witness, which is DW, defense witness. So DW1, DW2, like that, just like we have prosecution, PW1, PW2, and like that. And I'm talking about criminal matters now, stricter senses. We're not talking about civil matters, because those ones would have CW1, claimant witness 1, claimant witness 2, and then DW1 again, that's defense witness 1, defendant witness 2. So you call your witnesses, you examine them, then the prosecution will cross-examine them, and then you re-examine them one after the other, and then you tender all the documents that you want to tender in support of your case, and then you close your case and tell the court that's the case for the defense. And then the court will give you a date for you to come and adopt your written address, which you will file first, and then the prosecution will file theirs, and then you come back to court, both of you, to adopt it. And when it's adopted, the court will give you a date within 90 days, to deliver its judgment according to the constitutional requirements. And then you'll get judgment in the case for or against your client. So that's how to enter your defense if the court has asked you to enter it after a no case, or if you will not be going for a no case or resting your case on the case of prosecution, you would rather just defend your matter. So that's how to go about it. That's all I have for you in this video. Don't forget that you can always mail me at houseoflivingstones@gmail.com for all your inquiries and questions and collaborations, what have you. And you can always leave comments and questions in the comment section as well. I will see you in my very next video. Please like this video and don't forget to subscribe to those.